So hello everyone, myself Advocate Gautam Harshwal, working at LEXIS and Company law firm as a junior associate. So today in this video I am going to discuss with you recent judgment given by the Bombay High Court in a case related to sexual offense. You know, a sexual offense, or we can say sexual harassment, whatever you would like to call it, you can call it, because it's not just a term. Basically it's a offense. It is such a serious offense for the society as a whole, if we see, because in today's time men and women are being are equal in, right? Because there is equality before law. So what what prevents them on working, or prevents them because of such offenses? So this discussion will be on this, so don't forget to watch the video till end. Bombay High Court recently in a case said that reputation of women preserved like a jewel in society, and they are hesitant to report sexual offences. That's what the court has said that. And why the court has said that, I am going to discuss in this basically this video. While quashing Bombay High Court, while quashing a order that discharged a man teacher who sexually harassed a female teacher, the Bombay High Court recently observed that women in our society often hesitate to report such offences. The name of the case is XYZ versus State of Maharashtra. Justice Govind Sanap said that in such cases, women hesitate to report the offence as they feared it would affect not only their own reputation but also their families, right? Because if someone, if such reports are comes in public, their family's reputation also being defamed by such such culprits, right? And the court also said that basically the judge, Justice Govind Sanap, quoted. I'm going to quote him. He said that in such cases, the reputation of the family and the reputation of character of woman is at stake. It is to be noted that in such cases, one has to be mindful of the fact that the character and reputation of a woman in our society is preserved and protected like invaluable jewel. The woman in our society, as well as the near and dear, are therefore reluctant to come out in open against such a crime. The court also said, the Justice Govind also said that which has a tendency and prosperity to cause a direct dent to the character of and reputation of the woman. The order stated, right? So and further, the court was hearing, in this case, the court was hearing a plea filed by an assistant teacher at Zilla Parishad school who challenged the order of a magistrate court discharging the accused from the offence of outraging her modesty, right? As per prosecution, as per the prosecution case, the accused teacher in this case, the accused teacher made several sexual advances towards the complainant woman, who has differently abled persons, and once he had even moved his hand on her back and waist and sought sexual favors, right? And a complaint was later filed by the woman's family, after which police information report FIR was registered against the accused, and the magistrate court, while considering the discharge plea of the accused, noted that the FIR was lodged after several months of alleged incidents. It therefore discharged him on the ground of delay in lodging the FIR. So on that ground, magistrate discharged him. Noting the facts, the High Court stated that it was a general rule that the delay in lodging the FIR cannot be the basis of discharge. Obviously, the court also said that the court has to see the reason or explanation, if any provided in the FIR for lodging the delay, right? The question in this case, in such cases, is whether is explanation for delay in lodging of the FIR, and whether the said explanation is sufficient to accept the case of the prosecution. The judge opened, right? The bench noted that the complainant did not lodge the report initially on account of many reasons. Her children were grown up and educated, right? She further stated that in order to avoid defamation and humiliation in the society, she did not go to police and lodge the report. In her report, she stated in this case, in a report, she has stated that when all this became unbearable, she poured kerosene on her on her person and tried to set herself on fire. She also stated that she was saved by her husband and the neighbors. It further noted that subsequently the victim had made a complaint to the education officer, primary Jilla Parishad Chandrapur, and chief executive officer Jilla Parishad Chandrapur. Right. This was submitted to the Women Grievances Redressal Committee, which submitted its final report, and they said that the accused was involved in the serious crime. Right. And while causing the order discharge of the accused from the case, the court in this case said that, which is very important to note down, right? The court said that there was no reason for her to mailing her image and reputation in the society. She has narrated the same in her report. It is further pertinent to note that the learned magistrate has branded her report as a false report. In my view, at the stage of discharge, it is not permissible. And in my view, if the material on record is examined in jurisdiction with the settled position, it becomes clear that the approach of the learned magistrate was not in accordance with the law. This is very important to note down. In many cases, High Court overruled the decision of the magistrates. So this is one of the example of such cases. In this case, Advocate V.S. Lokhande appeared for the complainant, and additional public prosecutor A.R. Chupke represented the state. That's all about this case, and that's all about the discussion on sexual harassment. I hope you like it. See you in the next video. Till then, bye bye. But don't forget to like, share, and subscribe this channel. Bye.